How do courts set bail amounts for criminal cases? Imagine being in a situation where you or someone you care about is suddenly in jail. The first question that comes up is often, how much will it cost to get out? Bail is that amount of money you need to pay to leave jail while your case moves forward. But how do courts decide what that amount should be? It's not random, and understanding the process can help you know what to expect. When a judge sets bail, they look at several important things. The first is the seriousness of the crime. If someone is charged with a minor misdemeanor, the bail might be just a few $100s. But for serious crimes like felonies, the bail could be thousands of dollars. For example, a nonviolent theft might have a bail of $500, while a violent assault could be set at $10,000 or more. Next, judges think about whether the defendant is likely to run away before their trial. They check if the person has strong ties to the community, like family, a job, or property. Someone who has lived in the area for many years and has a stable life is less likely to flee. But if a person just moved to the area or has no roots here, the judge might see them as a higher flight risk. The defendant's past also matters. If they have a clean record and have always shown up for court, they are more likely to get a lower bail. But if they have failed to appear before or have a history of bail jumping, the judge might set a higher bail or even deny bail altogether. The strength of the evidence against the person also plays a role. If prosecutors have strong proof of guilt, the judge might set a higher bail to prevent flight. Community safety is another key factor. If the defendant has a history of violence or poses a danger to others, the judge might set a higher bail or decide not to grant bail at all. The goal is to protect the public while making sure the person returns for their court date. Courts also use bail schedules, which are lists that suggest bail amounts for common crimes. These schedules help keep things consistent and quick. Police officers often use these when making initial arrests. But the final decision is up to the judge, who can adjust the bail higher or lower based on the specific details of the case. During the bail hearing, which happens at the first court appearance, both sides make their arguments. The prosecutor might ask for higher bail or no bail if they believe the defendant is a flight risk or dangerous. The defense can argue for a lower bail or ask to be released on their own recognizance, which means they promise to return without paying money. There are different types of bail. Cash bail means paying the full amount directly to the court. Surety bonds involve a bail bond company paying the bail for a fee, usually 10 to 15% of the total bail. Unsecured bonds don't requiring money upfront but hold the defendant responsible if they don't show up. Sometimes, courts also impose conditions like electronic monitoring or travel restrictions instead of or along with bail. Bail can be denied if the judge believes the person is too risky or dangerous. If bail is denied, the person stays in jail until their trial. But if circumstances change, like if the defendant complies with all conditions, bail can sometimes be modified or revoked. Knowing how courts set bail helps everyone understand what to expect and how to prepare. Having a good lawyer can make a big difference during bail hearings. They can present evidence of community ties, employment, and good behavior to help get a fair bail amount. Remember, failing to appear after posting bail is a crime itself, so it's important to follow all court orders and stay in touch with your attorney. The system aims to balance fairness and safety, making sure people are not kept in jail unnecessarily while still ensuring they show up for their court dates.